Alright, so this is Decent With the People. Alright. This is gonna be the last one on this specific learning experience. Alright. And again, administrative law, a bill of attainder, right? And I have to say, due to my research, not attorneys or judges or anything like that, due to my research, really, if you sit and think about all the laws that have been passed and all that, only about 80% of the laws that's been passed is actually constitutional. Okay? Um, but that's due to my research. I'm not an attorney, not giving legal advice. So, how are they doing this? Is the question to be. Okay? And I personally believe this is one of the ways. I've talked about this on previous videos, right? The 4D child support is in fact a contract. It specifically says that in their own literature. Okay? And it says it must have consent. Okay? We, as dads, are tacit agreeing because we're under the illusion that we must follow these paperworks. Okay? And all this kind of stuff, right? And the woman that's coming after you, or vice versa, right? They're not the claimant. The Attorney General is the claimant. They are led to believe, in this case, woman is the claimant, but she's not. She's an informant, okay? And she's committing identity theft, right? She left you, and she's taking all your information, giving it to the courts or the Attorney General. In exchange, they're paying her for that information. Okay? Because even Supreme Court has told these 5 ladies that wanted more money that the states are not obligated to give you anything. So sit and let that sink into your head. If they're not obligated to give you the money that the father is providing for, then what was the sole purpose of child support? Sit and think about that and quander that for a little bit, people. All right. So, in fact, with the family court's issue is a bill of attainder. Okay. It's administrative law, but it's also a bill of attainder. And it's a contract issue, but we're not going in there as a contract issue. We're in the wrong standing of the courts. So when you tacit agree to something, then the judge does not have a choice but to rule on something else because there is a wrong standing. However, when you do challenge all these things is now they're committing criminal activities against you to bound you in this contract they cannot lawfully force you into. Okay? And I'm making this a little bit long, so I apologize on that. But I just wanted to kind of bring this issue up because the most crooked court system out there right now today is, in fact, family courts. And it's to benefit the attorneys of over and over and over. When you go into family courts, it's almost guaranteed to be fighting this for 18 years if you keep fighting it. Most people just give up and say, okay, I'm done. They do whatever they do. All right, let's go ahead and proceed forward on this bill of attainder. Okay. Anything I say or do is not legal advice. Do not take it as such. I'm just learning. This is a learning experience for all of us to think outside the box, right? Never look straight forward. Always look around you and be able to protect yourself by any means necessary. Okay. Hell versus Hinkle, I believe it is. All right. We are not obligated to take care of the states. So sit and quander that too.
Oppression. If this is what the founders intended, my question is, at what point did the people surrender this shield to administrative bureaucrats? When did the wall fall? Was the Constitution amended to remove Article 1, Section 9, Paragraph 3? Not in my copy. To the contrary, the prohibition is repeated to apply to all states in Article 1, Section 10, Paragraph 1. When did juries become more of a threat to the people group than a haven of protection? Legal experts will disagree. It is to expose those disagreements and consider each one with an open mind that I have written this paper. Please submit to me your disagreements or those arguments lacking.
I'm going to pause right there. Okay, so in this, he's not calling it out, okay? But what he's really saying in this paperwork, okay, is that the jury, no vacation, y'all. Okay, we are to challenge the law and see if that law should apply to whoever the jury is watching, right? But the courts are telling you you have to go by the law. But if the law is illegal, then how does it apply, right? As set forth, preacher, is unconstitutional, it's illegal. You cannot legally or lawfully make a law to steal something, right? The only reason why they're making laws and it keeps going on is because we the people. But yeah, they cannot make a law. In short, can they make a law that they're allowed to come to you and murder you? Well, no. But that's the same principle of any other law. They cannot make a law to steal from you. If you cannot do it to other people, then any law enforcement or whatever cannot do it to you. You know what that's called? Positive law.
Join me in confronting any bureaucrat you meet, asking how that agency seeks authority over you through legislative action designed to punish you. Ask where you can find in any law or court case that bureaucratic behavior can be justified, that bills of attainder have become constitutional, that we, the people group, was not to manage government, but was to watch over it and determine that no individual was oppressed by government or treated unfairly by any government officer or agent. Individuals were to be immune from injustice, with the immunity defined by ordinary people not employed within government. Those for the people, juries, were to provide a wall of separation between individuals and laws of Congress. Admittedly, that first Congress, charged both to regulate and not to apply pains and penalties, lived under a conundrum. How could they both expect regulations to be observed and not be required to present each issue to a jury? And to be required to present each issue to a jury. I have not researched those early years of congressional activity, so I do not know when the contradiction exposed in this paper developed. I am hoping my readers will enlighten me. No matter the instruction I receive, however, the contradiction remains. Administrative laws are the marks of bills of attainder. Do they violate the U.S. Constitution? We must try to solve this problem. Are congressional acts, state legislation, county and city ordinances constitutionally required to include jury review as part of the procedure mandated by administrative laws that regulate commerce? Does this make sense? The theory I present here makes sense to me. What does not make sense is that nobody writing on the subject of the U.S. Constitution and law has popularized this opinion. Of course, that means it is possible I have made a mistake in my research or in my reasoning. If so, I confess that my contact with reality is insufficient and that perhaps I belong in the loony bin. I cannot be faulted, though, for making public this writing for the purpose of finding my errors. I suspect it is our government that is out of touch with reality. Doesn't government have as much obligation to full disclosure as does a bank lender? Though all comers are welcome, especially if you are an attorney, you are cordially invited to set me straight, even an esquire, explaining where I am wrong. Here are my core questions. Is government out of tune with reality?
Let's pause that for a second, and I'm sorry again. Right. Now, we talk about attorneys. Okay, so let's just say I'm in a case and all that kind of stuff. But why am I forced into getting a license, wink, 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 attorney, instead of picking someone else that may help me counsel my way through this law stuff, right? Um, why do I must enter a contract with somebody that's in conflict of my interest in court? People sit and think about this. They're telling you you got to, if you're going to get an attorney, you got to have one by their bar members. That you cannot have, let's just say, your dad next to you to help you that may research laws for years. And the judge would just sit there, well, no, you can't do that. You can't do that. Sit and think about this and quander this, right? The bar member did not exist in the United States until the late 1800s. How did we survive without them before then? And now, why are we bound to be forced into a contract with someone that may be of conflict of interest to you? Food for thought.
Unable to read and abide by the Constitution? Or are capable readers of that document? Unrealistic for expecting government to display integrity. On the other hand, if I am not wrong, may we see a flood of objections to bureaucratic oppression and the filing of Title 42 complaints in federal court designed to rebuild that wall of protection, the authority of the jury. If you enter a court with the expectation that the judge intends to honor his oath to protect the Constitution as written, and if you challenge the judge to place his intent on the record, you might become amazed at how court procedure could work in your favor. Procedure means everything to a judge. Work into your argument the fact that any judge should be eager to follow the procedure demanded by the Constitution in outlawing bills of attainder, if that judge seeks to be faithful to the founding document. In the words reminding us of Patrick Henry, give me my constitutionally guaranteed liberty, or tell me why not. This is by Richard Palmquist. So, great article by a great man. I hope everybody learned. This is by Rick.
And I'm pausing it right there, just the simple fact that you could kind of check out the place, maybe get a copy of this, research it, and use this in your case. Now, I'm going to give you notice, right? You could try to force your attorney to use, but will they? Right? The number one issue, and we have Supreme Court cases over and over and over again, we have a right to challenge jurisdiction of the courts. and jurisdiction of the complainant, right? They must have standing, right? So the prosecutor is really the ones that have the jurisdiction. The judge sees, well, no, the prosecutor does have jurisdiction. Well, great. Can you show me verifiable proof of this this standing? Which one are we in? Um, you know, because constitutionally speaking, it's either common law or maritime law. There is no other laws in the Constitution, people. And we hear over and over and over, if you research the videos, people challenge jurisdiction, but the attorney says, well, no, no, no. That's a sovereign citizen thing. Then why is it in Supreme Court cases that they have to do it? They have to tell you. That's not a sovereign citizen thing. That's the Supreme Court telling all the lower courts they have to do it. I mean, you can't make this stuff up, people. So when you watch these videos and these attorneys that call them sovereign citizens because they're challenging jurisdiction of the courts, either they're lying to you on YouTube, and they did not study the Supreme Court's saying that they're obligated to tell you. Again, I'm just going to give you fair notice. I am not a sovereign citizen. That's an oxymoron. Okay? It's just a fake thing that people came up with, and maybe even the government came up with, to make we the people look bad for standing up for ourselves. All right. This is Diesel We the People News. Bye, y'all.